Some of you will have come in partway through the lunch presentation, where we just had a wonderfully rich account from Stein. This is him, David Stein, and full of Monica. I'm going to introduce I guess what you might call the first of the formalized panels now, and then we'll be running on through the day with the few minutes break after each panel for milling around. This being America, you're also free to get up and eat, drink and so on right during the middle of it. That was a very big shock to us immigrants to discover that was the way of doing it. So don't hesitate. I'm Benedict Kingsbury. I'm Vice Dean of the NYU Law School for Global Programs, and more so the Faculty Director of the Guarini Global Law and Tech program, which is, I guess, the core of organizing this particular venture. But although I'm the Faculty Director, I haven't done any of the actual work, and the intellectual and organizational effort of all of this has been put in by Thomas Streintz and Yurong Sun and Angelina Fisher and Stein, or in Guarini. So very many thanks to them for all of this. The context for us here, we're within this very good and energized and inspiring law school, which has a very strong intellectual property, information law, privacy faculty, sort of coordinated in the Engelberg Center, and also very active clinics in tech and policy and tech law. One of whose teaches us here today. And so we work a lot with them and with the Information Law Institute, for which Stein's one of the fellows, which Kathy Strandberg directs, and in coordination with the other parts of the law school and NYU doing this kind of tech-focused work, including here our Center on Cybersecurity. We have our program on corporate crime, our policing project, a large number of really gifted scholars and students working on all kinds of issues about equity and AI, use of it in government and policing, law enforcement programs, and people working on just about the entire corpus of law and the ways in which AI, digital tech, have an impact on it. So that's the wider context. We're just a little part of that. What we try to bring is the global thinking, international law, governance approaches to this, and in particular, intellectually. And this is, I say this just because you get a sense of why this program might not follow exactly the structure that you might ordinarily expect if you went to a law program about generative AI. We focused a lot on trying to think infrastructurally, that is to look at the core of the ways in which infrastructure is organized, by which we mean the technical side of infrastructure, but also its organizational forms for its governance, the legal and economic patterns within which it operates in, it is embedded, and acutely and especially the social elements of it. So we try to see all of those things together in thinking infrastructurally about law, and you'll see that approach going through different of the panels here, and also in the work of our students. So one of whom will be talking, and you'll be able to hear some of their work if you're here at the reception also and want to talk with them about it. So the thinking infrastructurally element gives a longer run, I think, from drawing a lot on histories of infrastructure, and perhaps a slightly different optic for this. Now, of course, that then brings in the compute questions, the exascale, the rapid growth in compute capacity, but also the demands which arise from AI and the ways in which the compute capacity and possibilities are distributed around the world very unevenly, and who controls them, and the relation there, and also edge computing, insofar as the models are going to be available on laptops and things like that. So that's got to be one side of it, is thinking infrastructurally. Second part that we've worked on a lot is we've tried to work on building a field called global data law. And that's really tries to put data as an object of regulation, of control power, the relations which are conveyed by data into the center of the inquiry, and then to look at how those sort of questions are being addressed around the world. And to what degree there is coherence or coordination or whatnot. So we want to integrate here the data elements, especially at the input side, but also in the output and the construction of relations, to integrate them with AI technology and the infrastructures that we're operating at. Third is we've put a lot of emphasis on developing countries and digital development, and the uneven distribution, the possibilities, the impositions, the visions of the future, the connections to how societies are to ways of governance, forms of political authority and control in different places, and how to chart a pathway for that. And we have a student externship on that. That's less visible in today's program, but I hope some elements of that really important question will come out, and that we can keep in mind those elements as we talk about the development of law, legal approaches, governance, and of course the construction of the generative systems and their deployment and the decision making about them, which tends to, at the moment, still be centered very much in a few very large countries. So we hope that those elements will come out as we go along. The kind of direct inspiration for this is two courses which are going on this semester, one on regulation of global digital corporations, and the other one on global tech law. And the first one taught by Thomas Streinz and Joseph Weiler, and the global tech law is taught by Thomas Streinz, Stein, and me. So, and you'll meet a lot of our students here. If you're not from the law school, please chat with them. They'll be really glad to chat with you. So that's our overall context, and this we're hoping here that generative AI, of course, is a lively topic at the moment, and there's some very pressing immediate questions of different sorts about how law and government corporations should respond, and how those are going to play out transnationally and globally also, and my own interest in planetary contexts, climate modeling, ocean modeling, space, near space, etc. So that's there's a short-term element, but we want to also situate this in a much longer run, long patterns. What do we know already? How to think forward and not to be too caught up just in the froth of the moment, and start to, as it were, make ideas about law and policy a little bit on the fly. So we hope we can have both of those spirits here. What's going on now? If you were here, you would have heard Stein just introduce where things are pretty much at the moment. And in lots of countries, different kinds of large language models are appearing. The Russian Sberbank just announced another one this morning, which seems to have a chatbot function and heavily trained in Russia. There's a lot of things happening in increasing number of places. So there's fast movement in all of this, but we hope we can also think that it's going to be different in 6 months, different again in a year, and radically different in 5 years. And so the efforts to make general laws, to make specific decisions, to frame angles have to be done in the context of what at the moment is legal time, which tends to be a lot slower, and decisions made now might lock in things which are not good for the future if they aren't sort of thought forward. So with that as the overall flavor of what we're trying to do, I'm really pleased to introduce this panel. So we've had a tech introduction already from Stein. He has a background in digital tech issues from MIT, and then was in the tech industry and Dropbox and a set of other companies for quite a few years. Then he did something which probably not a total rarity, but probably would have puzzled some of his nearest and dearest. He decided to drop all that and go to law school. And he came to this one, and he's just finished his JD and is now co-teaching in this program and a fellow in the ILI. And really it's about integrating knowing about tech with thinking about how law can be. And as he's ended rather sweetly with this possibility, which would have mystified, I think, many of the NYU public, that corporate law might be the answer to the problems of generative AI, but that's the kind of creative thinking that we look for a lot of. So he'll comment afterwards from his point of view, but we wanted to start with a wonderful colleague, Professor Kathy Sharkey, who is a celebrated scholar and administrative law and tort law in particular, real expert on preemption questions, very broadly on how administrative power is organized legally. And she over the last several years has been involved with the arrangements of administrative law in the United States and administrative agencies and in particular a review of how federal government agencies are using AI or not so far. They've published one report on that. She'll talk about it, and she's involved quite a lot in the question of what they should be doing and how a Minister of Law will play with that. But we've asked her to also talk a bit at the beginning, before she comes to that sort of work, how the government engages with AI in a legal context. Before she comes to that, to talk a bit about the possibilities of tort law itself as a form of control on AI, including generative AI, which most of the time will be ex post, different from the current, say, central thinking in the European Union about an AI Act. Canada may be going to follow that. But it's at least an element, maybe a very important element of the regulatory frame. We'll ask Professor Sharkey to talk to the tort topic and the government AI topic, and then we'll get a few comments from Stein. We're also going to do our best to let people ask questions, make comments as well. So with that.
Great, thank you. Thank you very much. It's a thrill actually to be invited into this conversation. To second something that Benedict said, it's a real privilege to do the kind of work that I do at NYU. So you'll see as part of my talk, I'm going to talk about how a lot of my engagement actually with machine learning, artificial intelligence, I was able to do by harnessing real talents that we get coming through the law school. So point number one is really just, I think, to deal with these kinds of issues. It's always been the case for the past, at least the past decade, but it's certainly much more important, I think, today, significant to think about interdisciplinary approaches. So to again echo a theme here, I think that thinking about the law's response to new technologies, new risks faced by society, increasingly depend on conversations and working groups that can actually have the combination. And in some sense, this is a show, not tell. We had Stein give the kind of technological backdrop for what I'm going to talk about in a few minutes about some of the work that I've done for the Administrative Conference of the United States. I was really able to do that because we harnessed talent here at the law school, students who had a technical background or even just students with an acute interest in the technology who could bring their legal thinking into conversation with technologists. I'll talk about that in a few minutes. But by way of sort of broad overview, for a long, long time now, I'd say my primary focus has been on thinking about tort liability and public administrative law together. And the idea is that when we face any kinds of risks in society, whether they are the kinds of potential risks due to machine learning and AI, or they're other types of environmental risks, banking risks, whatever the case may be, we should challenge ourselves to think not only about governmental regulation, but also tort liability. And although tort liability appears to be an ex post form, and some of our colleagues, particularly colleagues across the Atlantic, always want to think about tort liability exclusively as a kind of compensatory mechanism. As those of you who have had me both for tort law and in the seminar I've been teaching for over a decade on liability versus regulation, there's a way in which here in the United States, when we think about regulation of difficult risks, so take product liability risks, before we even get to machine learning and AI, there's, one could argue that we primarily regulate most products through threats of tort liability. For sure, we have certain highly regulated products like medical devices and drugs, but for the vast amount of products, we regulate through our product liability mechanism. And remember that I'll come back to that in a minute to talk about why product liability might reemerge or rear its head in some of these debates about algorithms and harms, et cetera. So I think it's worth thinking about. The second point, sort of a more normative point, I think we have some good examples historically, and my own normative point about thinking about new risks posed by machine learning and AI would harness this insight too. Tort liability can be a particularly effective transitional mechanism. In other words, whenever there's a lot of uncertainty about what an optimal regulatory framework would look like. We have not enough information. We don't yet know our predictive technologies. We're not confident enough in to know exactly what the impact of various risks would be. Tort law can function very well, actually, as an information forcing tool in transition, uncovering lots of information about not only products, environmental harms, and the like, that are quite useful. And there's a danger in terms of regulating too fast based on imperfect information. And so, as Benedict alluded to, much of my work looks at the interplay between tort liability and regulation, because of course, once you're past a transitionary period, if you actually have sufficient information to know how to optimally regulate, you could get a problem if you have regulation and then tort liability on top of that. And so I recognize that we could have potential over-deterrence problems, et cetera. But I think it is very worthwhile to give one quick example outside of machine learning AI, and then I'm going to turn to that. Fracking, some of you might have studied in environmental law as a kind of new technology that's being used to blast water to release certain gases. And there's a lot of uncertainty. And there's some scholars who are thinking about the idea that tort liability there could be a nice mechanism to allow for some kind of experimentation. We have a lot of built-in experimentation specifically in our US system with different state laws that have different reigning standards, et cetera. But it's a particularly good mechanism, I think, for gaining information where there's dramatic uncertainty about the ways in which to regulate. So now turning to machine learning and AI, as Benedict alluded to, I've done some work I want to talk about. But first, I'm going to start with when people think about the government in the field of machine learning and AI, I've noticed they almost inevitably jump to thinking about the government as the regulator. And of course, we have lots of examples, many of which I know are going to be talked about later in the day, including the EU AI Act. We have lots of things in the US context. We have the AI Bill of Rights that's come out with various principles, the Algorithmic Accountability Act of 2019, some executive orders, et cetera. But less focus is given to government as a user of these technologies. So I want to try to make the claim that in these conversations, it's relevant and important not just to think about government as regulator, but to take a close look at how the government is utilizing some of these technologies. And the first project that I engaged with was a report commissioned by the Administrative Conference of the United States, which is a federal independent agency. And this is back to Exhibit A on NYU student talent. I had 6 NYU law students who did a directed research with me for the year, and we linked up with Stanford. At the time, they were a little bit out ahead of us with regard to having the ability to bring together in what they call regulatory policy clinic, law students and computer scientists, data scientists. Seems like NYU has caught up and hopefully will surpass the ability to have these kinds of interdisciplinary types of opportunities. But what we decided to do was use this as a kind of microcosm, actually, of how we think these problems should be thought about. So we had, not only in the same room, but over the course of the semester, we had the computer scientists, the data scientists. So these were PhD students at Stanford, as well as law students, and then our NYU students. And we were able to cover a lot of terrain. We did a few things. First of all, we, I think, are the first to really systematically try to canvass the kind of uses of these technologies within government. And we found some surprising results. So first of all, we canvassed 142 different agencies or sub-agencies, the largest ones in the US government. We found that a large number of them, 45.1% actually, had planned, piloted, or implemented machine learning or AI techniques. So that, the main point of that is that the use of these technologies is definitely going forward apace within the US government. And it was a lot more than what some in the legal academy at least had expected. The other surprising kind of result was, of these that we studied, 53% of our use cases were developed in-house. So I don't want to overstate this. Many of these use cases were of a relatively low sophistication, but at least the legal literature at the time suggested that it wasn't that interesting to look within government. There wasn't that much going on. And number two, to the extent there was anything going on, it was through procurement of commercial off-the-shelf types of systems, and lots of worry about the use of those, because they would be black boxes, they would be proprietary, we'd have no idea what was going on with them. So that wasn't the reality of what we found. And we have a few reasons, I think, to be sanguine, I think, about the in-house development. So the report touches on this, and I have a ongoing new report where, again, I relied very heavily on NYU talent. You're going to hear later from Kevin Quarte Foderup on one of the panels. He and Giancarlo Carrozza were two NYU students who dedicated a lot of time, including, I'll just tell you that we had 48 hour-long Zoom interviews with government officials and representatives from outside contractors, and a few interspersed, academics and other thinkers in this area. But we tried really hard to kind of extend the findings from the first ACUS report. And I'm publishing a second report now that's the use of artificial intelligence in retrospective review. And again, the main point of that, and I have up on the slide here, one of the most interesting use case studies we uncover is in the Department of Defense. They're using this tool that is notably called Game Changer. It may be a game changer in terms of policy relevant kinds of applications that stem from tools. They're using transformer models of the type that Stein was kind of ending with in his technological primer to you. And it's really actually quite exciting. The technology here is open source technology. They have only kind of exploited, I think, the beginnings of how other agencies could take advantage of this tool. Thus far, it was piloted and used because DoD had what they called, quote unquote, mountains of policy documents. They had all sorts of inter-sub agencies that could all issue policy guidance, some of which was conflicting, some of which didn't point to who was responsible for what. And so they've utilized this technology to have a large repository of all of the relevant policy documents to come up with knowledge graphs to try to use some of the kind of insightful technology that Stein was talking about. In my mind, it has enormous potential. I guess to me, its potential to be a game changer is how it could be useful, not only in what this new report that I'm coming out with on use of this technology for retrospective review, which is after agencies, right, have passed rules and regulations to go back and to make sure that regulations aren't outdated, outmoded, redundant, et cetera, but how to harness these technologies in a forward-looking, prospective way. Now, none of this yet had touched upon generative AI. It'd be, as Stein said, the field moves really, really fast. And it would be really interesting actually to think about the ways in which some of these generative AI techniques could really be harnessed in prospective rulemaking within the administration. Very briefly, I also think the idea of the government as a catalyst in this area is really important. We uncovered a lot of instances where government agencies were both doing things like to highlight the FDA. They have programs where they have entrepreneurs in residence, right? The way to harness kind of talent from the private sector into government for shorter periods of time. They had what they called an incubator of machine learning and AI technologies. And in this incubator, they were publishing in peer-reviewed journals and the like. And we had some hypotheses about how what the FDA was really doing was trying to, quote unquote, de-risk some of the uses of machine learning or AI. And it's not surprising if you stop for a moment and you're a kind of student of the regulatory state and you think about which agencies within the US might you think would be the first movers in terms of use of machine learning and AI. I think HHS and FDA, which is within HHS, would probably come to mind. Why? Well, the FDA of course, is regulating medical devices and drugs, which are today incorporating machine learning and AI. So the idea that we would look within government for the buildup of this kind of expertise and maybe for some ideas about how to think about regulating these technologies at earlier stages, I think is a good one. So those are some partnerships. You know, why should we look at governmental uses? Why should we care about how HHS, how DOD are using these? I think that these are kind of like the main principal bullet points that we can think about. So one, I think that there's a lot out there about abstract principles, right? About mitigating bias, for example, about having trustworthy, responsible AI, about having transparent and accountable AI. Governmental uses of AI, specifically, I'm thinking here about the ones, you know, that will come up in rulemaking, are going to have to satisfy higher standards of reasons giving down the road when they're subject to judicial review within our administrative scheme. And I think that holds out, you know, this isn't just sort of like, you know, one would think in theory it works this way. Talking, as I did to a lot of both governmental and private sector entities that were developing these techniques, they would give examples of the kind of models or techniques that would work in the private sector, but they could not deploy in government because of the heightened need for this kind of accountability. So I think it's a particularly good way to find out some good ideas along those lines. Again, I'll just end with, this is the latest iteration of the government report, which is trying to look, it's just the tip of the iceberg, right? To look at machine learning or AI in terms of this retrospective review. But I think within it lies the kind of seeds for really thinking hard about how this technology will be very transformative in terms of the policy-making space of government. And again, that's another reason I think to pay attention to what's happening within some of our federal agencies. Final point that I'll just end on with my thank you, just to return for a minute to tort liability. Some of you might have been interested in the Gonzalez versus Google case that's pending before the US Supreme Court. And if you listen to the 3-hour oral argument, it was interesting. We're being taped. So it was very interesting. It went on for 3 hours. Much of that debate, right, was over the extent to which the Communications Decency Act, which Congress passed in 1996 to give broad immunity to ISP providers, how far does that go? Does it protect against targeted algorithms in this kinds of instance? And at the very end of the oral argument, to my mind, the most interesting issue arose when the lawyer for Google suggested that she was not as concerned about defamation liability, right? Defamation liability is tort liability for saying something that's false, that lowers someone in the estimation of the community. But what she was really worried about was potential product liability. And I mentioned to you earlier that product liability might rear its head. The extent to which information can be considered a product, the extent to which we should be thinking about our frameworks for regulating emerging risks by thinking about them as design choices and liability frameworks to try to making those design choices internalize some future expected harms, I think is a powerful lever that we should absolutely be thinking about, even though it does maybe seem quite myopic and US focused. Thank you very much.
Well, thanks, Kathy. Stein has been able to present on the tech. So he's given some sketch of that. It's something we spend a lot of time on in our technical class and others. But I also want to see if Stein had any comments to make on things that lawyers should know about this. That is moving a bit to his more recently adopted hat of a lawyer. So Stein, do you want to say a little bit? Then we'll invite any questions and comments of all sorts.
Sure. I think it's interesting you mentioned the project with Stanford, because one of the drums I've been trying to beat with relation to this is computer scientists might not be the community that makes sense to engage with when talking about AI. Because if for all of you are lawyers in this audience, and I don't know how much of my presentation on the tech you kind of just glazed over and went, this doesn't really matter for how this stuff works or how it impacts society and how it should be regulated. And I kind of think that's right. You know, the internals, understanding really deeply exactly how the math operates, I don't think is really necessary to understand like there's a system and it does a thing. And like maybe we should think about how that affects society. What I do think is useful when thinking about expertise is maybe thinking about how it's being applied. One of the things that made ChatGPT so impactful and why we're having this conference now and not 5 years ago when this technology was invented is because it was made usable, and it was made scalable. And those are corporate and infrastructural decisions that have to do with like capital expenditure and like product development choice decisions, and not so much about technology. And I think the same thing was coming up about agency use. This isn't so much about how the technology works as what it's useful for and not useful for. There's an instinct I think I've seen a lot of as people start to play with this raw, unfiltered thing, which is to kind of look at what it can't do or what it does wrong. I think it's worth keeping in mind as we try to think about how to regulate technologies, that we know what is possible from looking at what a technology does. Like it can do that, so that's possible. We don't really know what isn't possible. We have a lot of maybes. So can we train a transformer to not get facts wrong or to refuse to answer when it doesn't know? Maybe. We like haven't really done much research in that. Like definitely the like raw form GPT things we're playing with now aren't there. Is that possible? Open question, open area of research. And so I think when we're thinking about how to manage things, it's exactly right to be thinking about more setting the loss function, if you will, saying like, how wrong is this thing and like how wrong is it allowed to be? Because we need, in order to develop these technologies, the room to sort of tiptoe close to a mistake and go, oh no, we got close to a mistake, better stop and retune this thing, or else there won't be an opportunity to develop something like safety mechanisms. Developing a safety mechanism requires you to figure out where the problems are and define them well. And I worry a lot that an over-constrained regulatory approach too early will prevent us from making the safety mechanisms that we need for this to exist. Two other points, and then I'll open to questions. The first is on definitions. I don't know what AI is. In theory, I have like a number of advanced degrees that should tell me what it is, but as far as I can tell, it's just things a computer can do. And I spent a lot of time when working in the technology industry, trying to figure out what terms and regulation that also are used in computer science actually mean in context. Just defining the things, defining the terms, I think is going to be one of the really important tasks here of just making it clear which systems and which behaviors are problematic and which aren't. And it's something I'd like to see more of. The other thing is thinking about transparency in the context, especially in the context of like data protection with AI. A lot of these systems are transfer trained, right? You have one system and you like grab some weights from it that kind of worked and use it as the starting point for your next system. So we don't have chain of custody on the data that's in these things, and we don't know really where they went for a lot of the big models that exist now. And we don't have a great way to inspect the internals of any of these models. And so knowing what's in them and what's not in them, especially if it's potentially inferred, is an open area of research that we don't have answers to. And so I think when we talk about possibility, one of the things that's important to keep in mind is that like may be possible someday, doesn't mean possible now, and no amount of requiring it is going to like create that possibility. Again, to the point of leaving room to do things, I worry that things like really aggressive transparency requirements could create a situation where we never learn how to build transparency because we don't build things in the first place that need them.
Good. Thanks. Well, we invite any questions or comments people have, and there's a couple of roving microphones. Actually, like so much infrastructure, it's human machine team because it's carried around by Thomas and Angelina. So wave your hand if you want to. Yes, you waved it, so someone will try to reach you. Say your name if you want to, but you don't feel you have to. Yeah.
Hi, thank you so much. This is Anna Sofia, and I have a question specifically on product tort liability, because these generative models rely heavily in a user input to generate the output. So I just wonder where you draw the line on when you are being vicarious liable, or when you are not, or when your product is neutral, or is actually like making people do things that might not be lawful. And I guess it might be clearer once we have our actual resolution for Gonzalez v. Google. But when I think about, like, for instance, copyright cases, it has been clear that once, or if the product can be used lawfully, it has been considered that the developer is not liable. So I wonder how you see it working in this generative AI context.
Yeah, it's a great question. So the first thing to say is your question was exactly when the with the Google case pending, coupled with one of the surges of interest in ChatGPT. You all might have heard about Eugene Volokh ran an experiment where he asked ChatGPT about law professors who were accused of sexual harassment. And it came back with some names, including it came up with some hallucinations about a particular professor being in Alaska with a student. He'd never been to Alaska, et cetera. So a reporter called and was very much focused on defamation and holding the machine liable, and kept saying, how do we show the machine has actual malice for defamation liability? I said, well, that sounds very science fiction to me. And I'm not, so, but I would think about how we hold humans responsible. And I would, this is where I started to try to convince this reporter at least to think not just about defamation, although interestingly, the whole interactive idea is disrupting the framework of defamation liability and what it means to publish something when you have, user generated kind of conduct, or someone who's constraining users' choices and who's publishing what. But in product liability, I think you would look to, it's not like it's going to be easy, but you look to certain design choices that are put into the algorithm, et cetera, to try to assess that. And I guess I beg to differ that we have a framework that says once you have a lawful product, then we don't worry about liability. So I will point out, for example, medical, pharmaceutical drugs that have been approved by the FDA and are totally lawful, but they're out in the world and their new risk evidence comes to life, and there's an ongoing duty that's put on a manufacturer. And so in a similar way, if the programmer designer gets in a feedback loop, gets information about new risk evidence and how something's being deployed, I don't see any problem with tort liability addressing that. But I'm not going to say, we have many interesting questions. I'll give one other just concrete example where in this, Stein was a fabulous tort student, and I agree with much of what he said, although I think he rebutted his first pronouncement. So I need to say, I think he rebutted, but maybe I just wasn't clear about the interdisciplinary, getting the computer scientists, data scientists together with the legal thinkers. I saw in real time, for example, in governmental pilots where technologists were brought in, and there were the legal regulatory people within the agency, and they needed to talk to one another. The technologists actually needed, as Kevin can attribute, an administrative law primer that was designed to help them understand what happens in rulemaking and what it means to have common law development of a legal regulation that changes over time, et cetera. And the regulators and needed to understand what were the technological limitations at the moment for things like explainability, reasons giving, what would be possible. And so I absolutely am going to stand by that point. So it's not that that everyone has to go out and get a PhD in computer science, data science. It's that we have to harness these kinds of expertises in the same room. And then the second, the example I just want to bring up here is, the wait and see, give room. I'm all about not having regulations stifle innovation. Again, it's why I think tort liability, even much maligned, can be a nice transitional mechanism for some experimentation, because there are a host of examples, and I'm going to bring up one: regulation of direct-to-consumer genetic testing. For a long time, that was like the Wild West, and no one thought it was a product, and it wasn't being regulated by the FDA, and it was considered information. Now the FDA regulates it as a medical product. They came in belatedly once a large incumbent was existing on the market, and there are all sorts of problems about regulating after the market has created a huge incumbent. There are incumbents, for example, one last example, and then I'll stop. Think about Amazon and online marketplaces. There are decisions today holding Amazon liable as a seller. And frankly, Amazon, now that it was left unregulated for a long while, is perfectly fine getting behind legislation or bills to hold all online marketplaces liable as sellers, because it's a huge, massive market incumbent. So we have to, tort liability gives us, I think, a kind of experimental transitional regime. And I do think it could be potentially effective.
So I want to complicate that in two ways and clarify if you're there. I absolutely engaging with technologists, super important. I'm question whether computer scientists are the entire realm of technologists that you want to engage with, in the same way that in fracking, maybe talking to someone who designs drills is not the right person to talk to about the entire fracking system. Maybe you want like a geophysical engineer, like geophysicist or something. I think there is an over-index on computer science as the one relevant field, and I would like to see more systems engineering, people who work on like product management being engaged with in these conversations. I want to complicate the hypothetical here a little bit. So the GPT system can be implemented in about 200 or 300 lines of code. That are really easy to write if you read the paper. I did it to teach myself how the paper is written, and that's like a pretty standard practice, I think, for people who are trying to figure out how this works. The weights for the model, which are just a bunch of numbers, are the thing you need to make it work. And they're kind of just out there on the internet, which how do you think about tracing liability in
because if you get information back, so product manufacturing is very simple in the sense, in terms of a like simple analytic model. People always said things like, well, we have products and we weight costs and benefits, and then we send them out into the world. And that's just false, right? With drugs, you do testing up to a point, and then there's dramatic uncertainty. You've done 3 levels of clinical trial, but you don't get new evidence until it goes out in the world and you see what's happening. So in a similar fashion, you can start to get information back. And in fact, I guess it's not though hypothetical in this defamation context that arose in Australia, although I haven't tracked down the case, et cetera. A minister was falsely accused of something and let OpenAI know about it, asked about how this came about, et cetera, et cetera. So it's not like you put something out, and even though there's interface with other humans, et cetera, you can then be immune from liability. I don't understand that concept.
So we can take one more question, I think, and then we'll pause. Yes, I think, yes, go on.
Hi, I have a question kind of drawing on something Stein said earlier, but also coming into a bit about what Professor Sharkey said. So one thing you said earlier is that we, in some sense, just know AI is impressive things that computers can do, and we don't really know how, we don't need to focus exactly on how the individual manifestations of it work in terms of designing laws surrounding it. But what we do know, drawing on some of what you've shown in your presentation, is there's different segments of AI that work very differently. So for example, I think you had up expert systems, which have a bit of a more constrained form of, here's my knowledge base and here are the logical rules I follow. And then we have these more complicated deep learning neural nets that you can kind of just point to which neurons fired and which values they come out with, and it did the thing. So if you were talking about like whether we're taking a regulatory or tort liability approach to this, do the different areas of AI maybe fall into different approaches rather than just looking at AI in the whole, because they have different explanatory capabilities and that might lend them better or worse to having regulators in conjunction with technological experts look at these issues, as opposed to letting the tort system in a court among a jury of our common peers kind of make rulings over these issues. So I'm just curious if you have any thoughts about that.
You're looking at me, but I was looking at the torts professor.
Oh, he said he started, he said his question was directed to you.
I think that makes sense. And this gets to the little complicating question I tried to throw across the table. There are some things where they're kind of just out there. There are some things where someone sat down and made a decision. And I think intent has to factor into culpability in some way. And so it makes some sense to me that an intentional design that does a bad is more worthy of punishment or liability than an unintentional harm. And I think we can see that in like the pharma model.
Yeah, so basically, I mean, now we're gonna do all of torts in 30 seconds or less. So for intentional torts, that might be right? But for the whole idea of the whole vast rest of negligence and strict liability, the main consideration, right, should be placing liability on the least cost avoider. And what that means in this context is quite interesting and distinct, but I think it has nothing to do with intentional wrongful culpability, with due respect. It may be why certain intentional torts would be not where to look, but product liability is not an intentional tort. So I think it's fruitful. One final point, though, maybe a little bit responsive to this, is I think you're onto something in the sense that not everything is going to be ready to be deployed in particular, uses. And I think the government agencies that we were speaking to think about this a lot. So Stein mentioned something about we need to be able to come just to the line and think about failure. And people within the FDA talked about this a lot, about figuring out ways to fail cheaply and to have regulatory sandboxes where they do particular types of testing, et cetera. You're not going to deploy something out in the real world using sort of humans and what might happen to them to like be your regulatory sandbox about failing cheaply. That's like failing dramatically, expensively, and traumatically. So I think that to your point, we need to be attuned, whatever tort liability regulatory framework we're thinking about the context in which something is deployed and the type of testing that you want to have, say, a manufacturer to do in certain types of realms, et cetera. I think for sure it has to be kind of context specific in that way. But I think most of our, liability regulatory regimes, when you drill down, develop in a fairly context specific way so that the rules that are deployed, for example, for a FDA approved drug look quite different from them for a regular sort of consumer product.
Well, thanks. I think that we've already hit into the sensibility of just how much law is going to be involved with these kind of discussions. And we've picked up a few angles just in this first panel. And because we're trying to think globally, or even plan to raise, of course, this is going to look different in different places, and looks very different in the US, China, probably the EU and India to some extent, where there are very large markets and quite a lot of regulatory capacity, and particularly in the US and China, maybe Russia and a few others, where the tech's also being developed there. There's the scope for a lot of interaction with the developers, but it's going to be very different in smaller places or others who don't really have the capacity to change the way these very big enterprises are already being angled, and probably aren't going to draw sharp lines at their national borders. So there's going to be an overlays for question of what's the right approaches here. You see the OECD beginning to promote one of those, but that's going to also cause a lot of concern among other places. And that effort to generate more of a menu of ways of thinking about this and then to put those into dialogue seems to be one of the things also that universities can help with. Well, the way the conference unfolds now, so the next panel, which start in a few minutes, is on data protection, privacy kind of issues, being very familiar to many people. And of course, this has underneath it, perhaps that tension between the kind of safety, extreme risk orientations and the day-to-day human rights, ethics, data rights kind of dimensions. And sometimes those are come into tension amongst the advocates, although they seem to be probably coexisting. We'll then move on to trying to study how the supply chain might work, what the contracts and exclusion in terms of service, all that, how liability might be shifted there, how it might be refixed with tort and other kind of things, where it should land, and the ways in which different forms of official regulation might influence that. Potentially there's questions about insurance, cybersecurity, and so on. And there also, and of course, there's significant questions about Section 230, whether it's going to apply to these model producers and others still in question. So we'll discuss a lot of those things and elements of copyright and other kind of those sort of laws. Then we'll turn to something on infrastructure, infrastructural power. Infrastructure itself is a kind of regulation. We would expect it interacts with other forms of regulation, and we'll try to sort of work out at least some elements of those, the consumer protection kind of questions. But also, I think this possibility of a publicly provided infrastructure. India talks a lot about the India Stack now as a public digital infrastructure in India, although it's a lot of private companies involved. China is clearly providing a sort of state-based infrastructure and some elements of cloud blockchain and requiring registration of models is the same as seems to do for the metaverse and other things, at least according to the Cyberspace Administration of China draft. So there's a lot to discuss, trying to keep the infrastructural dimension here, not to get caught up just in the technology. I just want to emphasize that because we're certainly feeling from our own work. And then we'll turn, there'll be elements of different countries and regions proposed laws and all of that. We'll turn explicitly then to the transnational elements with the European Union's ambassador to the US will be coming. He's very interested in technology. And so he'll speak with Joseph Weiler. That's at 6 o'clock. Then it's our last session, 7:15, when people in East Asia have had some chance to wake up. Angela Zhang from Hong Kong, who's written really interesting work on Chinese tech regulation. So we'll talk about particularly the CAC draft here, but we'll also talk about attitudes in several countries in different parts of the world. So that'll be the last session. And then finally, there'll be a reception where you can also chat with some of the students. So that's the unfolding plan. It's the first of likely many on this whole topic, and really glad to have gotten off to such a ripping start. Thanks a lot. We'll convene again in about 6 or 7 minutes for the next panel.